Bushra Rashid,
Yes.
would you turn your video on for me, please? Mr. Olses, do you need to speak to Ms. Rashid?
I'll speak to her. Yes.
Get you into a breakout room. Ma'am, you're going to see an invitation to go into a breakout room with the attorney. Please go there. When you're done speaking with him, come out and I'll call the case, okay?
I don't know what that means.
Do you see a button on your screen that says invitated to the breakout room?
My eyes are bad. Bear with me. I'm suffering from eye disease. You say click on. I don't see a button. I see a button
Ma'am,
that says. Okay, can you repeat that, please?
Do you see something on your screen that says you've been invited to a breakout room or join a breakout room or something like that?
No, ma'am. It just says leave, mute.
Oh, no, Ms. Welch, I wasn't talking to you. That's okay. I was talking to Ms. Rashid. She's gone already.
Oh, okay. Sorry, Your Honor.
You're fine. No, ma'am, you're fine. Mr. Groen?
Good morning, Your Honor.
Good morning. Which case are you here for, sir?
I am here on the Citibank, Miss Welch matter. It looks like she might be here as well.
She is here. Ms. Welch, now you're going to see an invitation going to the breakout room. Just go there and talk to the attorney. And once you're done talking, come back out. I'll call the case, okay?
Okay.
Thank you, ma'am. Good morning, Mr. Rusin.
Good morning, Larry Judge Martin. How are you?
I am wonderful, sir. How have you been?
Oh, not too bad. Always busy.
I haven't seen Jamie Adair. If they're not here by about 9:15, I'll call your case and get you on your way, okay?
Well, that'd be just great. Thanks, Judge.
Thank you. Good morning, Mr. Collis.
Good morning, Judge. How are you today? Why is my video not working?
I'm good. How are you, sir?
I'm trying to fit. There we go. It's just delayed today.
Mr. Wilson is not here yet. My policy is about 15 minutes after the scheduled start time. So if he's not here by 9:15, I'll get you called and get you on with your day, okay?
Yeah, I'm just trying to figure out what's going on.
You were supposed to send a consent judgment. We haven't received it.
Yeah, we emailed it to him and he agreed to it on the record. Says if not signed by 3/7, we'll have another court date for pretrial. So not sure what happened that we don't have it. Let me see.
Good morning, Ms. Dillo.
Good morning, Your Honor.
You're not scheduled until 9:15, so I haven't seen Mr. Ladd yet or Mr. Ivanchek. Have you spoken to him?
We've had some communications, so yes,
Okay,
thank you.
this is 226280 GC. This is Calvary versus Rashid. May I have your appearances, please?
Good morning, Your Honor. Michael Olsey, here after plaintiff.
Ma'am, state your name for me.
Bushra Rashid.
Thank you. Today is the day and time set for the pretrial and the plaintiff's motion for summary disposition. The parties have had an opportunity to speak. Mr. Olsey, any resolution of this matter?
There's been no resolution, Your Honor.
Thank you. Ms. Rashid, did you receive a copy of the motion from the plaintiff's office? It would have, would have had a number of statements attached to it asking for entry of judgment in this case.
Yes.
Ma'am, did you have an opportunity to read those documents?
No.
Is there a reason why not?
Actually, I just kind of went through it. I didn't read page by page because I'm busy with the kids and stuff like that. So there's like 2 big envelopes sent to me, but I did not read it page to page.
Ma'am, do you have any response to what you did read?
Are you talking? Because there was 3 envelopes. I don't know which one you're talking about.
The one that's in your hand right now?
This one?
Yes, ma'am.
Yes. The thing that they're accusing me of, the TV that I did purchase, but I did return it. I did return the TV, and they did not give me a receipt or anything like that, you know, that the TV was defected.
That's what you put in your answer, ma'am. So then what's the next packet of information you received from plaintiff's office?
The next packet.
You said you received 2 big envelopes.
One was, I think, was just an agreement. One package that I'm looking at right here is like Citibank, and then it's just the agreement. So I didn't look over it because I don't know what to look at, you know, because there's just a lot of stuff writing on there. So I didn't go through that. I just went through, I didn't read anything on it.
Mr. Olsey, you want to proceed with your motion, sir?
Yes, Your Honor. This is the date, set, and time for our motion for summary disposition. Again, as it's kind of laid out in our motion, this was on March 19, 2017. The plaintiff opened up a line of credit with Citibank, which is the plaintiff's assignor. That was for a line of credit for a credit card with Best Buy for the purchase of a home entertainment system, including a TV and a stereo. In the breakout room, discussed with plaintiff that she claimed the TV was defective based on the records and account statements that contain herein. If she had returned the TV, that should have actually been on her bank statements. That amount was a credit for her on the credit account. But setting that aside, if there's whether or not that the TV was defective, that purchase agreement is different than the line of credit that was extended. She had a line of credit. She hasn't made payments. She is now defaulted. And the amount that's owed and outstanding is in the amount of $4,618.82. And that doesn't include costs, as the total cost was, apologize, The order has that was attached to the motion that was cost. I'm gonna find it here in a second, Your Honor. But as
It's 147.46.
Thank you, Your Honor. And again, as stated in our motion, she hasn't pled a meritorious defense with that in mind, and there's no issue of material fact as regards to that she did have this line of credit extended to, and that she has not failed to make those payments. As such, the motion for summary based on C9 and C10 should be granted.
Ma'am, your response to the motion?
I didn't understand what he said.
He's indicating that the plaintiff is entitled to judgment based on the statements that were attached to his motion. It shows that you were extended a line of credit, that you failed to make payment in full for the credit extended.
My credit was extended. Yeah, because I bought other stuff too, you know. I bought the fridge, I bought a stove and a microwave and everything, because I was getting a new house at that time. So I did pay for everything included, you know. But why would I pay for something that was broken and defected and return it the really next day, you know?
Did you hear Mr. Olsey just indicate that issue of whether or not the TV was defective is something separate than the credit that was extended to you?
I know, but that's what I'm saying.
Okay.
The credit was extended. It was because of the TV, right? That's what I'm
It's a
saying.
line of credit. It has nothing to do with the quality of, it's separate from the quality of the merchandise you purchased.
Yeah, but I did return the purchase, you know, so why would I make a payment on the purchase that I already returned? That's what I'm saying.
Ma'am, I understand what you're saying, but I'm also saying, Mr. Olsey's actually argued that that's a separate and distinct agreement. The quality of the merchandise and whether or not you receive funding for it are two different things.
Mm-hmm.
The court has reviewed Mr. Olsey's, the plaintiff's motion in its entirety will grant plaintiff's motion for summary disposition as requested in the motion, assign the order for summary judgment that was attached to the motion that has principal damages of $4,618.82, $147.46 in cost for a total judgment of $4,766.28. Ma'am, the civil department will mail a copy of the order to you at the address as it appears in the court file. Anything else in this matter, Mr. Olsey?
No, that is all set. Thank you, Your Honor.
Anything else, Ms. Rashid?
No.
That concludes this matter, ma'am. You're free to go. Have a good day.
Thank you, Your Honor. Have a
This
good
is
day.
226, you too, 226382 GC. This is Citibank versus Welch. May I have your appearances, please?
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff Citibank.
Ms. Welch, state your name for me, please, ma'am. Thank you. Today is the day and time set for the first pretrial in this matter. The answer is, Mr. Gruen, you've had a chance to speak to Ms. Welch. Is there any resolution of this matter?
We have reached a tentative solution, Your Honor, that we will memorialize a consent judgment. I have confirmed Mrs. Welch's address, so we will mail that out to her hopefully today. So I'm not for sure if the court wants us to adjourn this pretrial out for approximately a month to give the parties time to get that submitted to the court.
Yes, sir. That new date will be April the 4th, 2023 at 9:15 a.m. Ms. Welch?
I'm gonna pay Citibank, Your Honor. I owe them.
Okay.
And thank
Ms.
you.
Welch, what-
I forgot his name. I
Ms.
forgot
Welch,
your name.
what-
Thank you.
No, ma'am. What I was going to say to you is that the attorney has just indicated that you have a consent judgment that will be signed and submitted to the court.
Yes. Your
If
Honor.
you get that to the court, you do not have to come back on April the 4th, okay?
Okay, I'll read it and I'm gonna pay Citibank.
Thank you. Anything else, Mr. Gruen, in this case?
Thank
I
you.
think that covers that matter, Your Honor. I'm also here on a 9:15, so I'll hang out.
Bye.
Bye, Ms.
Bye,
Welch.
Ms. Welch. You have a good day, okay?
I'm gonna look for your letter.
Thank you.
I will mail it out today.
Okay, bye.
You're on the Citibank versus Hopewell Hatcher case.
That's
I
me.
am, Your Honor.
Mr. Munson just came in. I'll put you in a breakout room with each other. Mr. Brown, you can go back to number 2 and I'll put Mr. Munson in there with you.
Thank you, Your Honor.
Thank you. This is 226102 GC. This is LVMV funding versus Jamie Adair. May I have your appearance, please, sir?
Judge, may I please court? My name is Attorney Richard Bruson. My bar number is 35222. I'm the attorney of record for the plaintiff, and I'm the attorney of record for the plaintiff today in pretrial.
Thank you, sir. This case was scheduled at 9 o'clock. It's now 9:15 by the court's clock. Jamie Adair, there's no one by that name in the court's main session. There's no one in the court's waiting room. Mr. Ruzin, how would you like to proceed, sir?
Judge, at this time, I would ask for a failure to appear default based on defendant's notice to be here at this pretrial conference. I see that the notice was issued by the clerk's office on January 24, 2023, going to defendant at the same address on King Road in Romulus, Michigan, that was on his answered complaint. Judge, I can tell you that the case is on your docket today as an assigned debt. The original creditor was Sterling Jewelers. The complaint was filed in the amount of $3,645.51. The plaintiff has incurred statutory costs of a $75 summons filing fee, a $45.10 summons service fee, total cost of $120.10. Judge, I ask for a statutory $75 attorney fee in pursuit of this default judgment at this time for a total judgment of $3,840.61, and on that claim for us.
Thank you. Based on the defendant's failure to appear, default judgment will enter in favor of plaintiff and against defendant with principal damages of $3,645.51, $120.10 in court costs, $75 statutory attorney fee for a total of $3,840.61. Mr. Ruzin, your office may submit that default judgment by email to the civil department or snail mail, however you prefer, sir. Anything
Judge,
else in this matter?
Judge, I will forward that today by email before the end of day, and on that claim for us.
Thank you, sir. Have a good day.
Thank you, Judge.
This is 222388 GC. This is Davenport University versus Corey Wilson. May I have your appearance, please, sir?
For the record, Stuart Collis, P49530 on behalf of the plaintiff.
Thank you. Mr. Collis, this case was scheduled this morning at 9 o'clock. When the parties were last here on February 7th, there was an indication that a consent judgment would be filed. The court has not received that. Mr. Wilson has not appeared this morning. He is not in the court's main session. There's no one waiting in the court's waiting room. How would you like to proceed?
Your Honor, at this time, we'd ask for a default judgment. I had sent over the consent judgment immediately after the hearing, Mr. Wilson. That included a payment plan of $50 a month beginning, well, today's date, in fact. He has not returned it, not signed it. We put those terms on the record at that time, but I'll put them again on this time. And the amount of damage is $2,328 and it appears 46 cents. Statutory attorney fee of $75, court costs of $202.81, representing $75 filing fees, $60 in motion fees, $67.81 in service fees, for a total judgment amount of $2,606.27. Of course, that would accrue interest at the statutory 6-month rates. We'd ask that enter today.
Thank you, sir. Based on the defendant's failure to appear as directed by this court, default judgment shall enter with principal damages of $2,328.46, $202.81 in court cost, $75 statutory attorney fee, for a total judgment of $2,606.27. You would submit that to the civil department. You can send it by email or snail mail. The court has no preference. Anything else, Mr. Collis?
No, Your Honor, just hopefully you'll have a better day than I will.
Take care, sir.
You too.
This is 226383. This is Citibank versus Marvel Hopewell Hatcher. May I have your appearances, please?
Good morning once again, Your Honor. Brian Gruen, GROEN, number 56673 on behalf of plaintiff Citibank.
Good morning, Grant Munson, P71994 on behalf of the defendant.
Thank you. Today is the day and time set for the first pretrial in this matter. How are we proceeding, Mr. Munson?
Your Honor, the plaintiff and I have had an opportunity to talk. I think at this point, we're just looking for 60 days discovery, and we'll probably get it worked out before you see us again.
Thank you. 60 days discovery will start immediately and runs through May 8th, 2023. Can have you back on the civil docket for June 6th. June 6, 2023 at 9 a.m. If you have not resolved this case by that time, you can also use that date as a motion date. Pretrial motion date.
Okay.
Anything else in this matter, Mr. Groen?
I think that covers it, Your Honor. I appreciate it.
Anything else, Mr. Munson?
Nothing for me. Thank you. Have a nice day.
Thank you. You too. Thank you, sir. Good morning, sir.
Good morning, Your Honor. Sorry for my tardiness.
Miss, I was just about to give up on you. Do the two of you need to go into a breakout room?
I don't think so, Your Honor. I've been negotiating back and forth with, not Ms. Dillo, but somebody at her office. And we're very close to a resolution. I think we adjourn it out, maybe just 30 days and we'll be done.
This is 230353 GC, Capital One versus Sean Ladd. Your appearances, please.
Jennifer Dello appearing on behalf of the plaintiff.
John Ivanchik on behalf of the defendant, Your Honor.
Thank you. And sir, you were starting to say adjourn out maybe 30 days.
Yeah, if you wouldn't mind, Your Honor. I'm not going to say extremely close. I'm going to say we're right on the precipice of a resolution here. I will say that we will have it handled within the next 30 days with 99% degree of certainty here. Would have had it settled today, but they wanted a $10 payment, and I just thought that was ridiculous.
My next civil date is April the 4th, 2023 at 9:15 a.m. We will be back on Zoom 4/4 at 9:15. Anything else on behalf of the plaintiff?
No, Your Honor, thank you.
Anything else on behalf of the defendant?
No, just apologize for my tardiness, Your Honor.
Thank you. No worries. I'll see you next month unless you get your settlement documents into the civil department before then.
Okay, thank you, Your Honor.
Thank you, Your Honor. Have a good day.
You too. Good to see you.
You too.
Thank you. Good morning.
Morning,
Your name, please?
Wayne Bales.
Good morning, Mr. Bills. Your
Morning.
case is scheduled at 9:30 and you are the first one here for that case, so sit tight.
Okay, thank
And
you
we'll
very
get
much.
back to you hopefully soon.
Okay.
Good morning, Ms. Scheid.
Good morning, Your Honor.
I have not seen Ms. Kobus yet. My policy is
Okay.
about 15 minutes after the scheduled start time, so if she's not here by about 9:45, I'll call the case so you get on with your day, okay?
Sounds great, Your Honor. Thank you.
Thank you. Mr. Biggleman, I haven't seen Mr. Kennedy yet, but Mr. Bills is here. My policy is about 15 minutes. So hopefully he's here by about 9:45 unless you've had some communication with him.
I'll be waiting.
Thank you. Good morning, Mr. Kennedy.
Good morning.
Do you need to speak to either Mr. Bales or Mr. Biggleman?
I've already spoken with Mr. Bales this morning. If Mr. Bigman wants to talk, I'm happy to talk to him before.
I'll put you in a breakout room. When you're done speaking, just come back out. I'll get the case called and get you on with your day, okay?
All right.
Mr. Bales, it might not feel like it to you, but this is actually court. So I'm going to ask you not to vape and to take your cap off. Be prepared for your case to be called, sir, please.
Yes,
Good
ma'am.
morning, Ms. Stewart. Thank you, sir. Mr. Biggleman, Mr. Kennedy, are we ready?
I think so.
Yes, Your Honor.
This is 220143GC. This is Vision Restoration versus Wayne Bales. May I have your appearances, please?
Jeffrey Biggleman, on behalf of Vision Restoration and Building Company, Inc.
Jeremy Kennedy, appearing on behalf of Wayne Bales.
Thank you. Today is the day and time set for hearing in this matter. The parties were last here with me in September of 2022. The case was sent to in-house mediation with Judge Green. Came back to me as unresolved. I scheduled it for pretrial. How are we proceeding this morning, Mr. Kennedy?
Yes,
Your
Judge.
Honor, this is Jeff Bittleman. This is my motion. We had the opportunity to talk in the breakout room, and what we've agreed upon in resolution of my motion for default is if the court's so inclined to send us back one more time in front of Judge Brooke Green, with the caveat that if Mr. Bales doesn't appear at this third attempt for mediation, then a default judgment will be entered against him.
Mr. Kennedy?
Well, yeah, I think, Mr. Bales didn't make the last mediation because he had a pretty serious medical issue. A brown recluse bit him. So it wasn't that he intended to miss the mediation. We were at the first mediation. We were trying to get quotes on from contractors to finish the work at Mr. Bales' home. We have not been able to get that yet, despite our efforts to do that. But I think one more chance to mediate is in everybody's interest, rather than either arguing the default motion or alternatively setting a trial date. I think we can hopefully work this out.
Send the file back to Judge Green to reach back out to schedule for mediation. There's a note on the ROA now that if Mr. Bales fails to appear and participate in mediation, the matter will be back on with me on May the 2nd, 2023 at 9 a.m. for hearing on Mr. Biggleman's motion. That gives you just shy of 2 months to get on with Judge Green and back down here with me if you're unable to resolve it. Anything else, Mr. Biggleman?
Sure. One more thing. This was brought up in Mr. Kennedy's response. We sued both Mr. Bales and Mrs. Bales. Mrs. Bales died at some point during the proceeding, but our claim against her still survives, and we want that mediated too. And we're under the impression that that was to be mediated at the first two mediations also.
I'm sorry, say that again.
At some point during this case, from the time that the complaint was initially filed, defendant Kimberly Bales died. We are still pursuing our claim against Kimberly Bales, even though she's deceased. It was our understanding that at the first two mediations, that it would be, if we could reach a resolution, it would be a global resolution. We have not dismissed our claim against Kimberly Bales. The defendants have not filed any sort of motion or petition to dismiss her from the litigation. So we just want to be clear on that matter.
I've made that notation on the file that the claim against defendant number 2, who for the court's purposes is Kimberly Bales, remains. Anything else, Mr. Biggleman?
No, thank you, Your Honor.
Anything else, Mr. Kennedy?
No, Your Honor.
Thank you, sir. Have a good day. Thank you for joining us, Mr. Bales. Have a good day, sir.
Thank you.
Thank you, Your Honor.
Thank you. Ms. Frank, do you need to speak to Ms. Stewart?
Yes, please.
Ms. Stewart, you'll see an invitation to go into breakout room number 1 with the attorney. Please go there with her. After you've had a chance to speak, you come out to the main session. I'll get your case called and get you on your way, okay?
I'm sorry.
Mr. Bales, you're free to go, sir.
Thank you, ma'am.
Thank you. Mr. Burke.
I apologize, Your
This is 22 This is 224947 GC Beaumont Health versus Brittany Thomas. I'm sorry, sir, your appearance?
Thank you, Your Honor. I was just going to say I apologize for my tardiness. I was getting out of my 9 o'clock. This is Hal Burke, P69068, attorney for Beaumont Health on this case. And you know I like appearing in front of you, so I apologize.
Well, I was getting nervous because you're not typically late, and this was a 9:15 case. It's now 9:42 by the court's clock. The court has not seen Ms. Thomas this morning. There are no unidentified persons in this court's main session. There's no one in the court's virtual waiting room. Mr. Burke, how would you like to proceed?
Your Honor, would you consider a default, and I would file that under the 7-day rule so that maybe Ms. Thomas will receive it and contact us?
Thank you. That's fine, sir. The amounts due and owing in this matter?
Sure. The original balance was $4,083.15. With court costs and service of process, it's now at $4,345.60. And of course, that will be right in the proposed default judgment that I provide.
Thank you. This case having been scheduled at 9:15, it now being 9:42 by the court's clock, defendant having failed to appear, default judgment will enter in favor of plaintiff and against defendant with principal damages of $4,083.15. Once court costs are added, the total judgment will be $4,345.60. Plaintiff's office will submit that default judgment pursuant to the 7-day rule. Anything else in this matter, Mr. Burke?
Nothing further, and thank you, Your Honor.
Have a good day, sir. Good to see you.
Have a great day.
Thank you. This is 224991 LT. This is Trilogy Residence versus Ashley Colbus. May I have your appearance, please, ma'am?
Good morning, Your Honor. Jenny Scheid on behalf of the plaintiff.
Thank you. Today was the day and time set for hearing on plaintiff's request for a writ. Case was scheduled at 9:30. It's now 9:44 by this court's clock. There are no unidentified persons in this court's main session. There is no one in the court's virtual waiting room. Defendant having failed to appear, ma'am, how do you wish to proceed?
Your Honor, we are requesting that the motion be granted that we had filed for issuing of an order of eviction or a writ of eviction for this property.
The writ is stapled in the front of the file. The court will grant that application. There is a sticky note on the file that there is a $15 fee needed for the eviction. They called and left a message at your office on February 27th.
I got it right here in my
That's
file,
been
Your Honor.
rectified. Okay,
I will get that sent in right away.
thank you.
All right.
Anything else?
Nope, that's it.
Have a good
Always a
day,
pleasure,
ma'am.
Your Honor.
Thank you. Ms. Frank, Ms. Stewart is back. Did you ever make it into the breakout?
I did, and I don't know what happened with Miss Stewart. She appeared for a minute. I said hello, and she was gone.
Ms. Stewart, you'll see another invitation that go back into the, I'm sorry, go ahead.
It had just signed me out. I'm not for sure what happened.
I'm reassigning you to number 1. Please go there with Ms. Frank, and when you come out, I'll get your case called.
Thank you, Judge.
Okay. Thank you. Oh, she left again.
Yeah, I think she thought she might have to do something and hit the leave button.
She pops back into the main session. I'll give her a little better instruction. Ms. Stewart?
Yes, I'm sorry. It keeps
No,
just automatically taking me out of the room.
there's a different button there. It should say invitation to join breakout room. So you're not leaving. It's a different.
At least I know it wasn't something I said. And I don't think it was something you said. Just one of those Tuesdays.
It's not bad. We're almost done with the docket, so I have no complaints. How have you been?
I've been well. How about yourself?
Wonderful. It's a beautiful, sunshiny March day in Michigan. I have no complaints.
You know, I love snow in March because it means it's going to go away within a couple of days.
Except I was surprised by the little bit of snow this morning. It caught me off guard.
Well, my
Just
dog's
enough
got.
to see 2 accidents on the way in.
Oh. And my dog's got me up at 5. And I open the door. What is this on the ground? Whoop.
Hello?
Good morning.
Good morning, Miss Frank.
Yes.
Miss Stewart, have you changed devices?
No, I just signed into the Zoom. I was originally doing it as a guest, and I signed in this time.
You just came in a different name than you were before.
I
I'm
tried
not
to
sure
change.
what you. I was going to say I'm not sure what you're hitting that's causing you to leave, but I will try.
I'm
We'll
not
try
pressing
again. To put you,
anything. I haven't pressed
well,
the button, but
I'm
go
trying to
ahead.
put you into. I'm trying to put you into room number 1, the breakout room, to talk to Miss Frank.
Okay.
So you should see. I'm not going to do it. If she comes back, Miss Frank, I'll just keep her here. And I hate to do the conversation on the record, but there's something happening.
Usually it's me that's causing the problem with technology.
No.
Okay, I took my headphones out. I don't know if that was what was causing it, but let's see. Hold on, wait, you say one exception. No, I don't know what that is.
Don't,
Okay.
ma'am, don't do anything. Don't do anything yet. Give me one moment, okay?
Okay,
So you think it might be your headphones?
I unplugged them. So let's.
So I'm assigned, the attorney has already gone into room number 1. So
Okay.
I'm just sending you an invitation to go there. It's not working. Oh, it's working. Sweet. Good morning, Mr. Morton.
Morning, Your Honor.
I have not seen Mr. Morosky or Ms. Lee as of yet. It's still early.
Can I just confirm one thing, Your Honor? The court didn't receive any motion or was it or request from the other party, did they?
No.
Okay.
Should we have?
No, not to my knowledge. I assume this was set by the court on its own accord, but I just wanted to, check there hadn't been anything filed that I had not received.
No, he's here right now. And here comes Mr. Ali. Yay. Hey, what's Michelle's number? Thank you. Good morning. Is your boss here? Okay. When do you expect her back? I have a file that needs mediation date and I don't want to send it downstairs for it to get lost. Okay. Okay, thanks. Bye. This is 143198 GC Eastern Michigan University versus Samantha Stewart. May I have your appearances, please?
Good morning, Your Honor. Lori Frank appearing for the plaintiff.
State your name for me, please, ma'am.
Good morning, Your Honor. This is Samantha Stewart, representing myself.
Thank you. Today is a day and time set for hearing on the defendant's objection to garnishment and motion to set aside the default judgment. The parties have had an opportunity to speak. Ms. Frank, how are we proceeding this morning?
Well, Judge, unfortunately, we're not going to be able to resolve it. And I think you need to make a ruling on the motions.
Let's start with the motion to set aside the default judgment. The court did not receive a response from plaintiff's office be. Ms. Stewart, please proceed with your motion.
Yes, Your Honor. I wanted this case to be set aside because I do not believe that I was given. I do not. I was not. I was not. I cannot think of the word I'm looking for, but they did not serve me with the correct paperwork because I don't know if they didn't have the correct address, but they did not give me the paperwork, number one. And number two, Eastern Michigan failed to provide me with the paperwork to say that I owed them the debt in the first place. They had my correct address. I don't understand why it was not sent to me. I was not made privy to this debt until I started receiving the garnishment papers from Miss Frank's office. And that was even from my employer. They had to let me know. Now, they have my mother's address, and I have not lived with my mom since I moved from there when I graduated high school. Now, I have put in to the Postal Service that my address has changed a few times. I have my leases to show that I have not been staying there.
Anything else, Ms. Stewart?
I guess not.
As for the motion to set aside the default judgment, Ms. Frank, your response?
Your Honor, first of all, we sent the response to the court on February 28th. And so I don't know why it didn't get there, but be that as it may. Ms. Stewart is asking to set aside almost a 10-year-old judgment. And I attached the financial records from my client, which was Exhibit A to the complaint. And at the time, we believe she was receiving mail at her mother's address at 36115 Bibbin Street in Romulus. We served her by alternate means and then filed a default judgment. None of the letters that we sent were returned. And we believe that the court records will show that when it mailed a copy of the October 31st judgment, it was also likewise not returned. There have also been, as the court's records will show, a number of garnishments and post-judgment remedies. In 2017, we became aware of the 4th Street address, and we sent Ms. Stewart copies of the tax garnishments, the different post-judgment remedies, and she did nothing until we actually hit on the garnishment. And we found her current employer, and the only time this is the only time that she has contacted us, and it wasn't direct contact, it was through this motion. So to set aside a 9-year-old judgment that Ms. Stewart knew about at least since 2017 is highly prejudicial to the plaintiff, and under 2612C2, the motion has to be made within a reasonable period of time. And clearly 9 years is late, 4 years is late. And to have to litigate this after this period of time is not, doesn't make much sense.
Ms. Stewart, anything else?
Yes, Your Honor. Mrs. Frank says that in her opinion that a certain amount of time will be too late, which I agree. But then she gives her explanation of time, which is 4 years. 4 years from the judgment is 2012. That'd be 2016. 2017, she says that she reached out to me, and that, on her opinion of time, is too late to me. I think I do believe that I did file my correct paperwork with the Postal Service to make sure that my address was up to date with the Postal Service. And that is not my responsibility to make sure that they can get in contact with me. And I
Stewart?
I was never, yes, ma'am.
I'm interrupting you to ask a
Go
quick
ahead.
question. Ms. Frank says that she or her office, plaintiff's office, served you with a copy of the tax garnishment in 2017 at the 4th Street address. Did you receive documents, a copy of the tax garnishment in 2017?
I cannot say that I did, but I do not have them. I will say that I was having some issues with my neighbor parking in front of the mailboxes, and I wasn't getting all of my mail. They were sending mail back and forth from to me, and also back to the people who had sent it. And so I can't confirm that I got it, but I was getting some mail from law offices, but that was from a different case. And
let me ask, Ms. Stewart, let me ask it a different way. When did you first become aware? When did you first become aware of this case? Not when Eastern Michigan first got money,
when did I
or may
first
have
become
intercepted
aware?
money. When did you first become aware of this case?
When my employer had called me, well, she didn't call me. They sent me a letter, and they said that you're getting garnished for this case. And oblivious to me, I didn't know that I didn't even know that I had even had a case from Eastern Michigan, because like I have all my paperwork from Eastern. I got dozens of paperwork from Eastern Michigan, and I was even coming into this court to say that I don't owe them because of some probation that I was on, and I had to sign all this paperwork saying that I would pay them and that I couldn't register until I paid them. I was totally prepared to come in here and talk to you about something
Ms.
else.
Stewart,
yes.
The question is when. You said when your
Yes.
employer. My question is
my
when.
employer-
When is it? When is a date? When is 6 months? When is 3 years? When did you first know that this case existed?
My employer sent me the paperwork, I believe, beginning of February or the end of January. It was around that time.
So Ms. Frank and Ms. Stewart, the court is at a disadvantage because we don't have our original file. The file that I have right now only has the objection to the garnishment and the motion to set aside the default judgment. There is a history of post-judgment collection activity that starts in 2015, January of 2015, with orders of seizure of property, income tax garnishments. There's
and
wage
that is
garnishment.
That's what Mrs. Frank is saying, but I'm saying that I didn't receive this mail and then she says that she used alternate means. I don't know what alternate means you're referring to, because I didn't receive this in my mailbox.
Did Ms. Frank, were any of these seizures successful? Tax
No,
garnishment
Judge.
or the prior
No,
wage
they weren't.
garnishments? Okay.
No, Your Honor. And the only one that's been successful is the reason we're here today.
Ms. Stewart, what Ms. Frank said to you in the breakout room was regarding the time between the time the judgment entered and you filing a motion to set aside the default judgment. That default judgment by the court's records entered back on October 30th, 2014. Collection activity started 90 days later. There was mail that was sent to you by the court that was not returned. There was a substituted service of the underlying complaint. And the court records show that service was made by certified mail and by posting at the property without response. There's a multitude of efforts to collect this judgment over the last not quite 9 years. The court will find that your Motion to set aside the default judgment is denied after hearing the second matter before the court today is your objection to garnishment, Ms. Stewart, where you indicate as part of that objection that the judgment amount is incorrect and that you don't owe the company. Do you want to expand on that objection, ma'am?
Well, Mrs. Frank sent me some paperwork in the mail, and it shows a bunch of numbers regarding my time at Eastern Michigan. And I was under the impression that student loans had paid all this, but unfortunately, this paperwork says that it did not. And it says that I owe this amount. I cannot say that, I can't say that, this is incorrect, because although I will say I believe my student loans paid this amount. Yeah. I was getting student loans. I don't understand why I didn't pay it, so.
Ms. Frank?
Judge, what we sent Ms. Stewart was an accounting of the financial records to support the complaint amount of $4,762.50. And there's been no evidence or other indication that that amount is incorrect.
Ms. Stewart, an objection to garnishment may only be based on a finite number of reasons. Funds are exempt, there's a bankruptcy proceeding, there's an installment payment order, the writ was improperly issued, the judgment was paid, or the maximum amount allowable to be withheld by law is already being withheld. None of those conditions have been met in this matter. Your issue is as to the balance, not to actually that the writ was not properly issued. The court will find that your objections are invalid and order your employer to release all withheld funds to plaintiff's office immediately. Anything else in this matter, Ms. Frank?
No, Judge, did the court want me to prepare the orders?
There's orders stapled inside the file already, so no, ma'am, thank you.
Okay, you're welcome.
Anything else, Ms. Stewart?
No.
The court is signing the order stapled inside the file. Copies will be mailed to the parties at the addresses on record. That concludes this matter. Have a good day.
You too, Your Honor. Good to see you. Thank you.
Thank you. This is 224651 LT. This is Rawsonville Woods versus Crystal Lee.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Rawsonville Woods.
Thank you, Mr. Morton. Today is the day and time set for hearing on the plaintiff's application for an order of eviction. The court asked the civil department to schedule this matter as the application received on February 13th indicates $6,272 received, but that the defendant had defaulted by failing to pay February 2023 rent and utilities by February 5th, 2023. Mr. Morton, is it your client's position that they wish to proceed with the order of eviction?
Yes, it is, Your Honor. Was it that payment has been in default, and was it subsequent to that date, two additional payments have come due which have not been received. But at this point, I can advise the court that it's my client's viewpoint that, you know, this was a last ditch effort to be able to give Miss Lee an opportunity to be able to stay there. But was it after she made those initial payments, and the payments that were received were the $5,000, which was the lump sum at the beginning, as well as the funds that were being held in escrow. And those are the funds that have been received. So.
Thank you. This matter having been scheduled at 10 o'clock and now being 10:17, the court has not received a written response from the defendant's attorney. Neither the attorney nor the defendant have appeared this morning. The court will grant the plaintiff's application. The order of eviction has been signed. The file will be downstairs shortly. Mr. Morton, that issued order will be mailed to your office at the address as it appears in the court file. Anything else this morning, sir?
Nothing else, Your Honor. Thank you.
Have a good day, sir. Good to see you.
You as well. You're to stay safe, and hopefully that ice is gone now because it was not fun this morning.
Right.